When the Bill of Rights was added to the Constitution, it didn't have much about people's inherent rights, but had an awful lot about their rights in court. This is the bulk of Amendments 4 through 8, which if you do the math is half of the first 10 amendments. The actual process that defendants go through is pretty much protected at every level, since people before the Constitution could interfere anywhere with the process. First, a crime is committed. Let's say this guy, Al, steals some bread, and then he is caught and arrested. However, due to the protection of habeas corpus in the first article of the Constitution, the police need a probable cause for arrest before they do so. Once they jump over that hurdle and get a legitimate reason, they need a warrant to search his house for the stolen bread, since unreasonable searches and seizures are protected against in the Fourth Amendment. After they obtain the warrant and search his house, the police may find another offense, like a gigantic opium den, but they can't arrest Al for that until they get a separate warrant to search for opium den as well, unless the opium is made from the stolen bread. Finally, police find the bread and make the arrest, and are required to read Al his defendant's rights, since Miranda v. Arizona in 1966 proves that most Americans don't know as much about their rights as you do, since they haven't watched this video. Then, after telling Al that he has the right of counsel, and will be given a lawyer if he can't afford one, he finally gets taken to jail. At the trial, the prosecuting judge is forbidden from using any evidence obtained illegally as evidence in court. Were this trial taking place before 1961, this wouldn't be an issue, since the exclusionary rule wasn't incorporated to the states until Mapp v. Ohio declared that the government can't use their marijuana plants to claim that you don't gamble. Al, as the convict, also can't be used as a witness against his own case due to the protections of the Fifth Amendment. Such questioning has become so common that now the phrase, "I plead the Fifth," has joined the American lexicon, somewhere between "I was only going 50" and "I'm telling you I'm not drunk." After the court case, the required jury of peers gets to make a statement as to whether he's guilty or not, resulting in a ruling by the judge on Al's punishment. Under the protections of the Eighth Amendment, no sentence can be cruel and unusual punishment. Of all the parts of defendants' rights, this has garnered the most criticism and argument, since what one person considers to be cruel and unusual may not be for another person. The largest argument here is, of course, the death penalty, since death is the harshest punishment that can be given to a person. This issue has come up again and again in the courts, and the Supreme Court currently states that capital punishment is an extreme sanction suitable to the most extreme of crimes. The only definitive ruling on the death penalty is that it can't be the mandatory penalty for a crime, with the possible exception of shooting the president, since all 4 presidential assassins were killed for their actions. Luckily though, Al has only stolen a loaf of bread, so his punishment will most likely only be some menial work and service. Unless he shot the president. Whoops.